Welcome to Shenkman Education. My name is Marty Shenkman. This video clip is going to discuss an interesting case that occurred in Connecticut that's very important for trust planning, really important potentially for asset protection planning, which is how you protect assets from lawsuits and claims. It may be particularly important for domestic asset protection trusts, DAPT. A DAPT is a trust that you create in a state within the U.S., not offshore, that purports to protect your assets if you're later sued. And there's all kinds of requirements to qualify. We're not going to get into those in this case. The Netter case is really interesting and important for purposes of matrimonial divorce cases. So it has a lot of different implications. Let me explain the facts succinctly and talk about some of the lessons and a lot of the questions that kind of remain open. So if you are doing estate planning, trust planning, and you're married, if you're doing a self-settled trust, married, single, or otherwise, if you're looking and doing irrevocable trust planning generally, this is important to learn these concepts. It's not just relevant to Connecticut where the case occurred, because these concepts are important in many other states as well. Now, obviously, the law will vary by state significantly, especially in this context, but the lessons are very broad and affect lots of people. So in the Netter case, the marriage was getting shaky, and husband transferred assets to DAPT, really three of them, self-settled trusts. The trusts were established in South Dakota. South Dakota is one of the approximately 22 states that permit these types of trusts. What is a self-settled trust? I create a trust. It's got to be in one of the 22 states. It doesn't work in, for example, New York, California, etc. At the time of this case, it didn't work in Connecticut, but it does now because they have statutes permitting self-settled trusts. I set up a trust in South Dakota. I put assets in that trust, and I'm a beneficiary in my own trust. Historically, for most of history, legal history, this didn't work because you can't put, and it makes sense, you can't put an asset in a trust and say, oh, my creditors can't get at it if they're suing me, but I can still get at it. So states have now permitted that, 22 of them, so it's not an anomaly, but it's certainly not universal. And to make this reasonable and fair, there's a lot of requirements that have to be met. You can't commit a fraudulent conveyance. You can't make yourself unable for your creditors to reach, to pay your regular claims. So you can't do that. You can't defraud a creditor where if somebody is suing you and you know about it, now you put assets in a trust. That doesn't work. So there's a lot of precautions. You want to do a solvency affidavit, which is documenting that you're solvent after the transfers. You probably should have financial analysis done to prove that too. So that's a self-settled trust. So the husband and Netter set up 3 self-settled trusts in South Dakota, but he knew the marriage was on the rocks, and he put a lot of millions, I think it was hundreds of millions of dollars of assets in these trusts. And that's another complication, not for this video clip. Well, if the estate tax exemption is X dollars, how do you put 100X into a trust? There's techniques to make sales and other ways of doing that, not our topic. Also in this case, which is important to differentiate, and a really important lesson for planning for everybody transmitting wealth to the next generation, whoever you are, is dad set up for the husband a trust. So it's what's called a third-party trust. The husband had nothing to do with it. His father set it up. So in the case when the divorce came, husband said, you can't get in any of these assets in any of these 4 trusts. The 1 trust his daddy set up, and the 3 trusts that he set up for himself. And the court said, after evaluating it, they evaluated the trust dad set up and said, no, that's a third-party trust. He had nothing to do with it. It was set up. It's not part of the marital estate. Ex-wife can't get at it. Worrisome in some of the court language and discussions is they evaluated whether husband had control over the trust in terms of him being able to make distributions and so on. It's worrisome because under very common tax planning, you can set up a trust for, let's say, your child or your spouse, and that person who's the beneficiary can be a trustee as long as they're limited to making distributions to themselves to maintain their standard of living. It's a finite distribution restriction or pattern, The legal jargon is HEMS, health, education, maintenance, and support. But the court didn't really look at that. So it may imply that even if you're a trustee with a HEMS standard, even though that works from a legal and tax perspective, that the courts may be tinkering with that. So you have to be mindful of that. The best approach when you set up a trust for somebody else, make an independent trustee. You can have somebody as a trust protector to remove them if they're not taking care of the beneficiary right. But once you're a beneficiary in that position, I don't know if there's a chink in the armor with Netter, something to be mindful of, and it may depend on how careful you want to be. So if you're not worried about a creditor or divorce being a significant issue, you could be a trustee and maybe be removed later if things change. As to the 3 self-settled trusts, Connecticut said what you did, and the facts are awful. You're in a marriage, you know it's going bad, so you move the bulk of the marital wealth into a trust and say, ha, spouse, you can't get it, but I can. No court's going to like that. So the court said, yes, you establish valid South Dakota trusts. And most people don't even go that far to do it right, but they did in this case. But the court said, we don't care. You were a bad guy, you did bad things. Public policy in our state is you can't harm your spouse, your wife in this case, during a marriage by doing stuff like that. So they unraveled, they brought the assets, the transfer of the assets back into the marital estate so it would be available for equitable distribution in the divorce. So one of the worrisome things about the Netter case, does that suggest that any state may simply apply state public policy no matter where the trust is? The court didn't say these trusts were invalid. They were valid South Dakota trusts. But Connecticut felt it had an overarching public policy to address this. Another perspective on the Netter case is, hey, this guy was a bad guy. He tried to, at least the way the court case read, I don't know the guy, he did bad stuff in the middle of a faltering marriage. He tried to secrete assets into a trust that the wife couldn't, at the time the wife, not an ex-wife, would never be able to get to. And there's also questions that she didn't know anything about what was going on. And I'm not sure that's any different than if she knew what was going on but didn't understand it because no one ever told her and she had no independent counsel representing her. I don't know if it'd be any different. So Netter may just be saying, listen, if you're really bad and you do really bad things, the courts are going to find a way to pierce it. On the flip side, what Netter might be saying is, maybe there's a little, like I was describing earlier with the third-party trust from the father, maybe on a self-settled trust, the court is finding a way to say, we're going to exert our public policy wherever the trust is. That could be a big chink in the armor of self-settled trust, or maybe not. Hard to say. But I think it all reemphasizes you need more sophisticated, careful, thoughtful trust planning, the drafting, meaning the document itself, and how it's administered. So in other words, if you're going to make a plan, are you trying to defraud somebody? Are you being bad? You have ill motives? And by the way, how are we going to know that with hindsight? Document it. Do a solvency affidavit attesting under penalties of perjury that you have no claims. Do lien and judgment searches. Do background checks. AI is great for that. There's lots of neat stuff you can do and practical stuff to help demonstrate you didn't have any of these bad motives. If you do it really pristinely, will the same kind of arguments that the Connecticut court made come up in your case, whatever state you're in? No one can really say for sure. This is all very nuanced and complicated. It affects in many different ways everybody doing a trust. You don't have to be super wealthy like the people in this case. Talk to a professional advisor that specializes in this stuff. Think about it. You have to dig deeper. When you're hiring an attorney to do an estate plan, or however you're getting it done online from somebody else, by the way, you need to ask questions. You can't just say, how much? You need to understand the nuances in this planning because those nuances may save the day if something happens. So you could get a boilerplate trust online for your kids set up, but that trust may make them trustees of their own trust. Might you have a problem like the court analysis in Netter? And Netter, it didn't end up mattering, but is that a chink in the armor? Do they really need to be a trustee? If they're a trustee and this HEMS concept isn't integrated, they lose under all counts. So getting a trust document and thinking you're done isn't going to solve the day. And if you're uber wealthy, try not to be too cute. Little cute may be okay, but you got to be mindful of what you're doing. And in this case, it was bad facts and the husband got a bad result. So lots of lessons to learn for lots of people, not just the limited consequences in this case. Thank you for joining me. I know this was complicated, but it's really important. And by the way, a lot of times real planning is complicated, so don't be put off by that. Maybe you should be put off by stuff that sounds too simple to be true, because it's probably not true. The 30-second TikTok estate plan is not going to do it for you. Thank you for joining me. Please keep in mind that all the video clips, including this one, on Shenkman education are for educational purposes only. Don't take any legal or other action without appropriate professional advice. I love legal disclaimers. Thank you for joining us. And for more information, see www.shenkman, SHENKMAN, education.com. One word, shenkmaneducation.com. Thank you.